So just the other day, we did a segment on this show, and I titled it, "The Supreme Court is effed." Now, why? Why did I do that segment? Why is that my opinion? Because the approval rating of the Supreme Court at the moment is literally at an all-time low. All-time. All-time. So it's 29% in one poll. That's abysmal. 31% is their high in a separate poll. And look, usually when you talk about the Supreme Court, it actually has this aura of seriousness that other branches of the government don't have. But now they've just destroyed that. Why? Because they're deeply political actors. They are activist judges, and they're basically ruling in accordance with their own personal philosophies and dressing it up in fake legal arguments. And so the public's sick of it. The public's sick of it. And they see it for what it is. It's nakedly transparent. And so, for example, Roe versus Wade is phenomenally popular, and they slapped it down. Apparently, the Chief Justice of the court was like, please don't totally get rid of it. You can tighten the standards, but don't totally throw out Roe versus Wade. The conservative justices did not listen. They made their bed. Now they're going to sleep in it. Another thing is there's all these corruption cases that come in front of them, one involving Andrew Cuomo's aides recently. And the Supreme Court was like, corruption, schmaruption. This doesn't hit our quid pro quo bar, so we're okay with corruption in this instance. There's been a number of cases where they come to that conclusion. So they're losing all legitimacy. I stand by everything I said in that segment. However, I could not see this coming. It looks like the Supreme Court has now made at least two decisions to sort of ameliorate the damage and hold on to their legitimacy. Now, let me be clear. I nor anybody else saw this coming, this decision that they just made. But it is a very positive decision. Okay, so here's what they say in Democracy Docket. They say U.S. Supreme Court rejects what's called the independent state legislature theory in Moore versus Harper. On Tuesday, June 27th, the U.S. Supreme Court issued a 6-3 decision in the landmark case Moore versus Harper, with a majority of the court ruling to reject the radical independent state legislature theory. I'm going to explain what that is in just a second. In the pro-democracy opinion authored by Chief Justice John Roberts, the court held that the Elections Clause does not vest exclusive and independent authority in state legislatures to set the rules regarding federal elections, and does not insulate state legislatures from the ordinary exercise of state judicial review. Roberts was joined by Sotomayor, Elena Kagan, Brett Kavanaugh, Amy Coney Barrett, and Ketanji Brown Jackson. So you have Brett Kavanaugh and Amy Coney Barrett are conservative justices, as is Roberts, and they joined with Ketanji Brown Jackson, Elena Kagan, and Sonia Sotomayor to say, yeah, we're going to be more pro-democracy in this instance. Justices Clarence Thomas, Neil Gorsuch, and Samuel Alito dissented. So, okay, let me explain what's going on here. This case involves the North Carolina state legislature and state courts. What the legislature is saying is, hey man, if you read the Constitution, it's the state legislative bodies that have basically unlimited power to set the rules of an election. So that includes gerrymandering, for example. That includes, if we happen to not like the outcome of how the people voted, since we effectively have been vested with all of the powers to determine what happens with elections, we can throw it out if we want. So we can say, oh, the public voted for this person. We disagree as the state legislature, the Republican state legislature. We're going to say the other person won. Now, the reason why this was terrifying is because if they ruled the other way, guys, make no mistake about it, the Republicans have been getting more and more brazen with how anti-democracy they are. And I have no doubt that in some states, they would have been like, we're going to reverse the decision because we want to. If they feel tremendous pressure from somebody like Donald Trump, from a Republican administration, if it becomes a partisan litmus test on the right that, no, we actually won the election and you need to get us to that point, they might just throw out the results of a democratic election and say, look, this Constitution says the state legislature determines the rules and regulations around the election, so we can gerrymander however we want, and we can throw out the result if need be. Now, in this instance, it was the North Carolina state courts that were like, well, hold on now. You guys don't have the independent and exclusive right to do whatever you want regarding federal elections. You like the exclusive right, so you guys have the last say, the people don't have a say, the courts don't have a say. So basically, the courts were like, we disagree. And so we give ourselves the power of judicial review at the state level to say, you're not carrying this out in a fair way, in a legal way, in a constitutional way. So this came to the Supreme Court. And again, the fear was that since it's a very right-wing Supreme Court, they would say, you know what? We're going to interpret the Constitution as meaning it is the state legislatures that get to determine everything about elections, and we're basically going to take power away from the courts and let the state legislatures make their own conclusions and decisions. But the court didn't do that. In fact, the court did quite the opposite. They upheld the idea of judicial review at the state level overseeing elections, but also by extension, they upheld the federal courts and the Supreme Court and their ability to do judicial review when it comes to elections. So in other words, if they think there's funny business going on and the state legislature is acting in an unfair way, they can step in and say, that's not legal, that's not constitutional, you're wrong, and we're overturning your result. So look, make no mistake about it. In no uncertain terms, this was the correct decision. What's crazy is that there were 3 people that disagreed. Clarence Thomas, which is no surprise. He's wrong about basically everything. Neil Gorsuch, I'm kind of surprised by that, but not really. And then Samuel Alito. I mean, this decision it's a decision to effectively destroy democracy. They're okay with destroying democracy. And my guess is their argument would be, if you do a literal reading, the originalist interpretation of the Constitution, it does say that the state legislatures, the states decide what goes on with elections, so we're going to go ahead and let them decide it. But, the other people are arguing, but if you're gerrymandering in a way that's unfair, right? If you're just overturning the will of the people, no, that's not okay, that's not fair, that's not just, that overrides the idea of one person, one vote. And so we're not going to allow it. So thank God they made this decision. And this also comes after they recently made another decision where they said, no, the gerrymandering here is racist. It is biased in favor of Republicans and against Democrats, and so you need to redraw the lines on that map. So that's 2 decisions in a very short time frame that was like, okay, they're trying to gain back some of their legitimacy. I talked to Crystal about this. That's her theory. She says, look, John Roberts is not an idiot. I might disagree with him politically, but he's not an idiot, and he knows that the court is on the ropes in terms of the perception from the American public and how far they can push it. And so this is them saying, okay, yeah, maybe we overreached in some instances, and maybe we did things that are super unpopular, and our approval rating is all the way down in 29% now, but let's go ahead and make up for that just a touch and do a decision that is correct. Now, by the way, so this was the biggest case, don't get it twisted, of the day. And we're going to get more cases coming out soon. And by the way, I'm sure a number of them are going to be like horrifically wrong decisions, and we'll talk about them when we get those decisions. Like the student loan debt case, there looks like they'll likely throw that out. I don't know. We'll see. But we'll talk about those cases when they come. There was one other case that they did, which I wanted to share with you as well, because I actually think they got this one correct also. So this was in the Washington Post. Supreme Court says a conviction for online threats violated the First Amendment. By the way, that's not a fair headline. You'll see in a minute what I'm talking about. Prosecutors must show that a person responsible for threats understood the threatening nature of that speech, justices say. So this was a First Amendment case. Let me give you some of the specifics. The Supreme Court on Tuesday reversed the conviction of a man who made extensive online threats to a stranger, saying free speech protections require prosecutors to prove the stalker was aware of the threatening nature of his communications. In a 7-2 ruling, with Justice Elena Kagan writing for the majority, the court emphasized that true threats of violence are not protected by the First Amendment. That's an important point. True threats of violence are not protected by the First Amendment. But to guard against a chilling effect on non-threatening speech, the majority said states must prove that a criminal defendant has, quote, consciously disregarded a substantial risk that his communications would be viewed as threatening violence. Justice Clarence Thomas and Amy Coney Barrett dissented. That's interesting. With Barrett writing that the standard set by the court on Thursday gives preferential treatment to a broad range of threatening speech and makes it more difficult for law enforcement to address actual threats. I disagree with her categorization of that, and you'll see why in a second. Quote, a delusional speaker may lack awareness of the threatening nature of her speech. A DV speaker may strategically disclaim such awareness, and a lucky speaker may leave behind no evidence of mental state for the government to use against her, Barrett wrote. The court's decision thus sweeps much further than it lets on. The case concerned a Colorado law used to convict Billy Raymond Counterman of stalking and causing, quote, emotional distress to Coles Whalen, a singer-songwriter he had never met. Counterman, who had previously been convicted of making threats to others, served 4 years in prison in the Whalen case. That's a long time, man. The court's interest involved the question of when statements, especially those made online, can be considered true threats. not protected by the First Amendment. Counterman contended that the state must show that the speaker intends the message to be threatening. Colorado, backed by the Justice Department and a majority of states, says it should be enough that a reasonable recipient feel that physical harm could be imminent on the basis of the context of the circumstances. The case returns to the lower courts where prosecutors could decide to retry the matter under the new standard set by the Supreme Court's decision. So let me go on. I just want to give you the messages that we have. So again, basic facts of the case. You have somebody who's basically repeatedly harassing a singer and songwriter, okay? Here's what they say. Whalen eventually that's the singer-songwriter, eventually sought help from a lawyer who researched Counterman, that's the guy who's doing the threats, background, and told her of his previous convictions. Quote, I was already scared, but then I was terrified, Whalen said in the interview. I thought, why did I wait so long? Among the messages presented at Counterman's trial, quote, so these are the threatening messages. I'm currently unsupervised. I know it freaks me out too, but the possibilities are endless. Another one is F off permanently. Another one is, you're not being good for human relations. You're not being good for human relations. Die. Don't need you. So when you look at those messages, and my guess is, since these are the ones they're presenting in the article, these are probably the scariest of the messages. When you look at these messages, they are scary, but you got to keep it real. What is illegal speech under the Constitution is libel, slander, defamation, and direct threats of violence, and, maybe a handful of other things. The question is, does this constitute a direct threat of violence? And I think the court got it right. I don't think it does. And the fear for many of the justices, which again I think is true, is if we were to rule, guilty in this case for this guy, then that does leave a chilling effect on speech. Because I don't know if you guys have ever been on the internet. It's like, this is a random Tuesday on the internet. Now, by the way, I'm not saying it's good, but look, as somebody who's been the recipient of a lot of stuff exactly like this, I don't think people who do vague things like this, even though it's bad, even though it's wrong, even though it's arguably unethical, they don't deserve 4 years in prison over something like this. This is called trolling. This is called shitposting. Now, if it was a direct threat of violence, I'm coming to kill you, and you're not going to know when it hits, but it's gonna. That's a different scenario. That is lock them up, right? That is a direct threat of violence. Usually even direct threats of violence get more specific than that. Like, I know where you live. Here's your address. Watch out. Like, those are direct threats of violence. This is a little too vague. I'm currently unsupervised. I know it freaks me out too, but the possibilities are endless. F off permanently. You're not being good for human relations. Die. Don't need you. It's just not direct enough. And so, look, the guy already spent 4 years in jail anyway. So there's already been, I think, a hefty punishment for it. And I think the Supreme Court got it right. You got to be careful when treading the line on freedom of speech. Because if this standard is set, I got news for you, there would be millions more people in prison based on just shitposting online and trolling online. And again, I'm not condoning this. It's not a good thing. As somebody who's been a victim of stuff like this, I understand why somebody would want to, take action and stop it and snuff this out. I get it, 100%. But the lines are actually very clear. Direct threats of violence, libel, slander, defamation, maybe a handful of other things. I'd be fine with adding doxing to that list because that is threatening by its very nature, right? But this just doesn't cross that line. So this is the Supreme Court yet again upholding the idea of freedom of speech. And I do think that if this was a little more specific, he would have gone down and I would have been fine with that. But I think they made the right decision, especially since you already spent 4 years behind bars. But that's 2 decisions from the Supreme Court in a very brief time frame where I'm shocked they actually got it right. But we'll see. Buckle up because we got more decisions coming out and my tune will probably change. Almost certainly it'll change within the next week or so because, if they make the wrong decision on the student loan debt stuff, if they make the wrong decision on some of the other stuff, yet again, we're back to devastating and their approval rating will remain around 29%. But by the way, here's the final point. I'm still definitely of the opinion you got to use court stripping. So, the legislative branch needs to say, we're not allowing the court to rule on X, Y, and Z. I'm definitely in favor of that. The Constitution allows for what's called court stripping or judicial stripping. I'm definitely in favor of packing the court. I'm definitely in favor of term limits. I'm in favor of a number of ways to put the court back in check, because it is true right now they're judicial supremacists and they're judicial tyrants. I just happen to agree with two of the decisions that they just, made here. But this one is the most important, super important pro-democracy decision. And then this one right here is just upholding the tradition of free speech case law in this country, which is a good thing. But we'll see what happens moving forward. Hey, y'all, do me a favor and like and subscribe. It helps out big time in the algorithm. Click the bell as well for notifications when videos drop. And watch that video on screen right now. You know you want to.